My Lords, I'm done with the facts relevant to the first argument. If I may, just two areas to cover briefly the second argument, and then a few words about the way in which our case has been represented so that you don't get confused when you come back to it. If there was, as a matter of fact, no extant controlling interest in UDL at the time the SHA was entered into, and at the time Horace acquired his controlling interest, it is our humble submission that the words used by the parties have then failed to give effect to the parties' real intention that Clause 11 should apply equally and mutually to all four contracting parties, and that these words must give way to that real intention. We've seen the evidence already this morning, my Lords, and I would simply ask you to note that the respondent has never and could not challenge the evidence, as one, it emanates from each of the four parties' signatory of the shareholders' agreement, and two, Horace and its principals have no knowledge whatsoever of the circumstances in which the SHA was entered into or of the negotiation thereof. Instead, UDL, under its new management, has sought to contend that the parties' evidence of their common intention should be ignored because Clause 11 was claire et précise. As I have shown your Lordships this morning, that is not the law. That is what they managed to convince the Court of Appeal of, but that is not the law. Even a clear and unambiguous clause must give way to the parties' real intentions. That is our submission. Applying the law, therefore, we say it doesn't matter whether Clause 11 was in fact claire et précise or not. But for the sake of completeness, let me remind you that our submissions on that point are contained in paragraph 45 of our case. So we do say this clause was ambiguous. Indeed, we respectfully submit that it cannot seriously be contended that it isn't. To take two of the points made in our case, which we say suffice to demonstrate that, if I could show you a passage of the transcript before the first instance judge at page 442, which makes it plain that he himself thought the clause was ambiguous, although he then purports to find it isn't. Page 442 of the transcript. And they're discussing paragraph 57 of Mr. Rivalon's, of the affidavit, which contains the evidence from Mr. Rivalon, and you see the fourth entry on page 442 of the court. He could have said, if there is a change in the board of managing of the company, he puts it in a language which nobody can understand. That's the way he put it about how the clause was worded. And the respondent has sought to explain that away by contending that the learned judge there was struggling with the language.
I really think that to ask us to place weight on a conversation with a first instance judge about the meaning is a bit pushing it, isn't it? What weight does this have? We either form the view that we can understand it or we don't.
Indeed, my Lord. I was just going to say, the only explanation that has come back is he was struggling. These are the words in the respondent's case at page 636. He was struggling with the definition of controlling interest, not with Clause 11. Well, the definition of controlling interest is part of Clause 11. And the second point I would make is that there is at the very least a tension between Clause 11's express application to any shareholder and the respondent's case that the clause could purely and simply not apply to UDL when applying the literal wording of the clause. So for those reasons, we say it is ambiguous. I've shown you what we say the unanimous evidence of common intention is. Firstly, that the clause should apply mutually to all parties. And secondly, that the mischief targeted was a change of control. I pause to note here that, as I noted in opening, a change can be described as a loss when it is assumed that there is an existing controlling interest. On the other hand, if there is not such an interest, the party's intention requires reference to the broader notion of change, which encompasses both a loss and an acquisition of control. And that, I would humbly submit, includes the position where there's an acquisition of control from a position of no control, because there is a change of control, moving from no control to existing control. It follows that if the combination of the parties' use of the word loss and of their imported definition of controlling interest results in the clause being altogether inapplicable to UDL, the clause's literal wording must give way to the parties' real intentions, and I have made the point, my lords, that I am not submitting that in every situation where you get common intention of this sort, which of course will be rare, because normally the parties will be on opposite sides of the litigation. What has happened here is that because of the way this litigation has shaped up, it so happens that you are in the rare position of having common intention from all the contracting parties, but that is of course not the end of the exercise. That doesn't trump the task of the court, which is to assess whether that evidence is plausible and to then give effect to it. And we say that the evidence is really exactly what one would expect it to be, that the clause was to have mutual effect and apply to all shareholders, including UDL. This is entirely consistent with business common sense, with Clause 10 of the shareholders' agreement, with the overall scheme of the shareholders' agreement, and with the close-knit nature of the company. The board will note that it is also consistent with a piece of evidence produced by the respondents, Mr. Galea himself, in the proceedings, and that's a board minute of UDL of the 26th of May 2006. If you could look at that, please, you will find it at page 175. The minute starts at 174. So 174, this is a procès verbal of a board meeting of the 26th of May 2006, and the relevant passage relating to access is on the following page, and I rely on the final sentence. The general manager, that is Mr. Rivalon, added that the shareholders' agreement is going to be signed, and I emphasize the following words, so that all parties are assured of fair treatment, of a fair treatment. Le général manager ajoute qu'un shareholders agreement sera signé afin que toutes les parties soient assurées d'un fair treatment. So this statement, which emanates from UDL itself, at the time when the agreement was being negotiated, is entirely consistent with Mr. Rivalon's evidence that the shareholders' agreement and its clause 11 was to apply equally to all shareholders.
So this was made just before, the shareholders' agreement was made just before the purchase of 18% in UDL.
No, my lord, it's some time before. It's made at the time, you can see, just before the shareholders' agreement itself is entered into. The shares are then acquired on the 18th of July.
So it's yes, but that's 18 days before.
Yes.
That would be.
Well, this is a
month
minute
and a
of
half.
26th May. The 30th June was the agreement,
Yes, I see.
and 18 days later was the share acquisition.
Yeah.
So your point is that this is a clear indication of the understanding of UDL that the agreement was going to be, quote, fair to all, not just to anyone other than UDL.
Yes, my lord, because I was asked, are you relying on anything further than just the testimonial proof of the witnesses? And I am. I rely on this as being entirely consistent with that testimonial proof. So that we humbly submit that the board ought to hold that the party's intention was that the option would be triggered if, following a change in the shareholding structure of UDL or any other party to the agreement, there was a change in the prevailing situation of control of that party. It ought also to hold that that was satisfied here, since, one, there was a change in the shareholding structure of UDL when Horace acquired 18.27% shares of UDL, two, following that acquisition at a meeting requisitioned by Horace.
Is there an inference that that clause 11 was put in, was agreed in awareness that there might be a change in the shareholding interests of one of the partners?
Well, I cannot put the case like that. That is certainly a question that crossed my mind when I was preparing this appeal. Yeah. And you may have noticed that below, my friend tried to run a case of illegality by analogy to poison pills and the like. But that is not being pursued before the board. Yeah, no. But I do rely on that board minute to show clearly what they had in mind. So we say, my lords, that the option was triggered and the appellants, I humbly submit this appeal should be allowed on this second alternative basis. Just a word before moving on to the other side's case, about third-party rights, the exchange we had earlier. I would say this, that as the buyer, and I understood that by third party, what we are looking at is Horus, the position of Horus. And Horus, of course, is the buyer of the shares. So its sellers have full knowledge of the clause, one would assume, and in terms of
would it necessarily?
Well, in terms of due diligence within the company, it's certainly something that
one would assume it would discover the shareholders' agreement. You mean? Well, I don't know. It bought it from other people, didn't it?
It did, my lord, but a shareholders' agreement is something which would obviously be required in any due diligence exercise. I humbly submit. So it's not.
If UDLs had entered into a shareholders' agreement, as it had, possibly to protect itself against this sort of event, people buying shares in UDL from other third parties wouldn't have any means of knowing about it.
Well, they could certainly have conducted a due diligence exercise which would have brought about the existence of that agreement. That's the first point.
Would they? I mean, would they have the right to see it? It's not a public document, is it?
But it's a shareholders' agreement of the company.
But they're not buying from UDL, you see.
They're not, my lord.
How do they get hold of it? I mean, do they write to UDL and say, we're thinking of buying from another third party some shares in you? Would you please disclose us all the agreements you entered into?
They could have asked the existing shareholders they were purchasing from.
Yeah, but why would the existing shareholders necessarily know?
I mean, this is an issue which arises. No one's taken the point.
No, my lord, you're quite right. And I was going to.
But I mean, if it might be relevant to the third party point.
You can write. I mean, whether or not it arises in this case, your approach to interpretation will have significance more generally.
And that, my lord, is the broader point, which is, of course, this criticism that through the task of interpretation, or indeed rectification or rectification by construction, courts may be affecting contracts in a way which affects third-party rights has been one of the criticisms of certainly the Hoffman approach, as I understand it, to construction. And it has, as I understand it, it has been accepted as something which may occur when one has this form of subjective interpretation. And I would simply draw the board's attention to this, that contrary to English commercial law, which has long been attached to certainty over, forgive me for putting it that way, but justice. And I say that not in a pejorative way at all, because the assumption has always been, well, the trader had rather know that he's going to lose, even if it's not just, so that you can settle your affairs on that basis. That, broadly, in my humble submission, has been the approach of English law. Well, I think one has to understand that French law has never had that approach, and it may explain why. In the arbitrations I am involved in, international arbitration, you will never see a French governing law clause. It's very rare that parties that have nothing to do with French law are going to opt for French law, whereas...
But don't let's deviate too much.
No, my lord, but I say this because when looking at the way in which French law interprets the agreement, it could be easy to overplay the way in which we look from an English law point of view at certainty in business transactions. The point goes no further. That's all I meant to say. And finally, on the value of the assets, I have found a reference for my Lord Hodge, which is page 157 of the... paragraph 16 of Mr. Révalen's evidence, page 158.
Yes, thank you.
Yes, 2.2%.
So, all right, your case simply affects the very limited assets which UDL has in the form of shares in the company.
My lord, yes.
Yes.
Again, I reiterate, there is no spoliation because they're losing the shares, but they're getting the equivalent in money on a fair market basis.
Yeah.
My lord, to finish, I've prepared a handout just to take things quickly about the misrepresentations we say of our case in the respondent's case. I'll just take...
But I think you ought to bring it to a close now.
Sorry?
I think you ought to bring it to a close. So if there's a handout, you can hand it in. But
No,
Mr. Burton
I don't believe you. They haven't seen that. I prepared it over lunch.
Well, you better be very quick about handing it around.
Thank you, Lord.
But
And it's relevant to the procedural objection, so... Yeah. Two for you.
Pardon me.
right.
And my lord, all I'm going to do now, if I may, is...
Now, I think you've got to bring your submissions to an end.
Yes, exactly. So all I was going to show you, the only relevant factual passages are the last two bullet points, which are relevant to my friend's procedural objection. And it's paragraph 8 to 9 of his case, where he says that we are running the point differently now because we're relying on the July 2006 acquisition, whereas below we were relying only on the October 2006 change of board. And that's incorrect. And you find this from page 185, which is a summary of our argument before the interim measures judge. Subparagraph 4.
That's the interim measures judge. What about... Well,
Yeah, Mrs. Justice Chong.
yes, but the interim measures judge isn't the judge who heard the case.
No, my lord, but that just to show you that already from the very outset of the case, it's being said you never said that below.
Well,
Here it is,
You've
number
got to
4.
show...
The argument of Mr.
But
Persim...
it doesn't matter because, clearly there was something happened when the new board took over, and indeed when there was an acquisition of new shareholding. But not quite sure why this difference matters.
simply because it is being said that we have changed our case, and
I know.
this is why it's a new case. But that's, the references are there, my lord. You've got Mrs. Justin Chong in the interim measures, you've got a Court of Appeal argument by my learned friend himself, and you've got a letter from Mr. Rivalan, which from the outset made the point that they were relying on both.
Right.
And
All right.
paragraph 55(6), it is said that we never contended before the lower courts that there was a conflict between the parties' true intention and the intention expressed in clause 11. With respect, that is just completely wrong. If you look at Mr. Sauzier's submissions at pages 440, 442, that's exactly the point that is there developed. And you can see, if you turn to 44, he refers at 440 to Article 1156, at 441 to the evidence at paragraph 57. He says at the top of 442, this is what he said, Mr. Rivalan. So we have been, according to this paragraph 57, they have been negotiating for a long time. They have been reducing it in writing, and the clause is a nonsense. And he says, 3 lines from the bottom of that quote, this is not the intention of the parties, this is certainly not, it means a change of control. Change of control ultimately comes to the board and there is a change. So the argument that the intentions of the parties as reflected in the affidavit evidence meant change of control was clearly made. If you look at Mr. Persim's submissions himself on that same hearing, pages 436 to 440, and you see that in the first quote at 436, he's saying 4 lines down into the quote, of course, this only becomes relevant, that is the position of Horace, if your lordship reads 11.1 to cover merely an acquisition and not a loss of controlling interest. Then over the page, second paragraph, couldn't be clearer with respect, my lords. My learned friend refers to paragraph 57.5 of the affidavit of the applicant. That's where the evidence of Mr. Rivalor was reproduced. Next page, if your lordship is prepared.
Look, I think you must be aware that you probably used up all your time in reply.
Very well. My lord, that concludes what I would say.
Yes, Mr. Webster? Yeah. Mr. President.
Your Lordship have taken cognizance of the response of the respondent to the letter of my learned friend dated the 23rd of June, where we have reiterated our objection to the points which have been raised by my learned friend, which in our humble submission, we say that these are completely new points. As we have indicated, we would take both the objection and the merits of the point together. I would wish to deal with the first one in relation with the issue of controlling interest, because it's the respondent stand, firstly. Now, this is a point which is completely new, which was never taken, so that it is not open to the appellant to raise it now.
Sorry, which point is this?
With respect to the fact that there was a controlling interest which was lost at the time of the acquisition by Horus.
It's the case founded on paragraph 5711. It's that point.
Indeed,
Yeah.
indeed. The point we'd wish to make, my lord, it's not a purely procedural objection because it goes to an issue of jurisdiction. The chronology becomes important because your lordship will bear in mind that the change in shareholding occurred sometime in July 2006. The change in the board occurred in October 2006. Now, the request made to the respondent with respect to the option was made sometime in December 2006. The response of the respondent came on the 29th of January 2007. Now, perhaps I should pause here to say, right from the outset, on the 29th of January 2007, when the respondent was faced with the request by the appellant invoking the option, right from the word go, the respondent indicated that, look, there has been no loss in controlling interest because there was no controlling interest at the time of the acquisition by Horus. Now, in spite of being made aware of this position, we know that when the appellant went before the judge in chambers, the focus of their argument, and that is reflected in the affidavit of the applicant at page 35, your lordship would have seen it. The focus then was clearly on the change in shareholding. Change in directors. Your lordship will see.
It's paragraph 7 at page 37.
Indeed, my lord.
Yes, October 2006, yes.
Yes, I think the relevant paragraphs, if your lordship turn to page 4227, where reference is made to the listing rule, we'll come to these.
Sorry,
and then over the page, page 44, there is reference to the acquisition by Horus. At paragraph 33, it is submitted that Horus has the effective control of the board of directors of UDL and controls the majority of the board. It is clear that the new board of UDL does not share the same investment policies and vision. And then it says, 35, it results from the above that as far as the applicant are concerned, it is beyond the shadow of a doubt that there has been a major change in the controlling interest of UDL. My point being that right from the stage when the matter was brought before the judge in chambers in relation with the injunction, the focus of the appellant, bearing in mind that most, if not all of them, were signatories of the shareholder agreement. The focus was on the change in the board of directors.
Well,
At no point in
effective
time.
control. I mean, effective control involves either 20% shareholding or shareholding plus effective control of the board. And by this time, it's quite clear that Horus had effective control of UDL, and that's not in dispute.
No,
That is not in dispute.
but your point is that what is not being put in issue that was the fact that prior to Horus's purchase, there was not a controlling interest.
That is indeed the
But
case.
in
And
the
we-
terms that had been a change in control resulting in part from an acquisition of a shareholding, that's not in dispute, as I understand.
That is not in dispute.
The whole question turns
That
on
is
whether
not
you
in
need to have a loss of control, and that you say, insofar as they're arguing that someone was in effective control before, then you'll say that's a new point.
Indeed.
But
Perhaps it,
I think you're also making the point, aren't you, though, that the focus was not on the July acquisition, it was on the October 2006 change in the
I
board.
mean, that doesn't matter.
Well, it may not matter, but it just helps us know what was being argued about and what was an issue.
yeah.
Yes.
Now, there was a response by the representative of Horus to the affidavit of the applicant. That response, Your Lordship will see it at page 139, where Mr. Gallia, at page 140, clearly makes it very clear that, look, there was no controlling interest at the time of the agreement. Paragraph 6 of the affidavit of Mr. Gallia.
Yes, but you see, it doesn't matter. No one's trying to put in fresh evidence now. It really doesn't matter how they argued it in the past. What matters is what the right legal analysis is of the material which was before the court, isn't it?
Yeah. My Lord, the reason why I say this, I said the case, the focus, right from the outset, in the
Yes.
Chambers case, and in the main case before Mr. Lamshine.
They were talking about the proof of the pudding being in the eating. Yes, they were talking about the board change, demonstrating that there had been a change of control. Quite.
Now, the pertinence of the point I'm raising is this. If the cause of action was in relation to the change in the shareholding as opposed to the board, my submission is that there has clearly been a shift in the course of action because the change in the shareholding occurred in July, whereas the focus of the appellant was the change in the board of directors. So that all throughout, the case which was run by the appellant was not that, well, there has been a loss of controlling interest. The focus of the appellant was there has been a change in the board. Now, we say that this is extremely important because almost 10 years down the road, the first time today the appellant is saying, well, at that point in time, there was a controlling interest. There was a loss of controlling interest. The point becomes pertinent because by virtue of the Mauritius Code Civil, and I refer here, Your Lordship, to the page 3 of the document which we have just filed in the course of the recess, where les actions personnelles, my Lord.
Do we
Number one.
have that in the bundles? Do we have it on electronically?
Which document is this?
Which has been filed in the course of the recess, my Lord. The response of the
First respondent's response.
yes, the first respondent response to the appellate letter.
Yes, thank you.
No.
Paragraph.
What we say
Yes, I'm not
is that
right.
Sorry,
this-
what paragraph is it?
it's the footnote below, paragraph page 3.
It's the time bar point.
Yes.
Indeed. The factual element which was relied by the appellant is the change in the board, which occurred in October. I said almost 10 years down the road, now what the appellant is saying is that, look, there was a controlling interest and there was a loss in the controlling interest. My submission is that it's not purely and simply a procedural matter. It goes to the jurisdiction because it is not open to the appellant today, almost 10 years down the road, to come and say, look, there was a change in controlling interest and there was a loss of controlling interest, and the court below were wrong not to have identified that controlling interest and the loss of the controlling interest. I say that because we have made that very clear in our statement of case, be it before the judge in chambers, be it in all the affidavits which have been filed in the course of the main case, where the respondent made it absolutely clear that, look, there was no controlling interest. At no point in time did the appellant respond to that. On the contrary, the response which came from the appellant was to the effect that, well, they almost admitted that there was no controlling interest. Now, for that reason, we say it is not open to the appellant today to reopen that issue or to open that issue freshly before your lordship.
Well, it depends how narrowly you define cause of action, doesn't it? It's the same cause of action if you look at what they're trying to do, namely acquire the shares which UDL has in the company in Axis.
Correct.
It may rely on slightly different facts, so you might be able to argue insofar as the cause of action consists of the essential facts necessary to give rise to a claim in law, that there's a new cause of action, but it's a nice point. Is there not a provision in Mauritian law allowing you to rely on a cause of action, a new cause of action arising out of substantially the same facts as an existing one? There is I ask because there is in English law.
I can't recollect.
No,
but your lordship's point is...
It's a little bit difficult to call it a new cause of action, isn't it? It's an action to enforce the same clause in the same contract.
But on the basis of slightly
But on different factual basis.
Well,
I agree with
the argument is different, that I understand, and you're absolutely right, and you're entitled to make the point very, very clearly. But how far it takes you, I'm not so sure.
I mean, a cause of action has been defined as the essential facts necessary to sustain a claim in law. So that's the basis, as I see it, of your position. But what about the next point you make, which is, given it wasn't taken below, you didn't have the opportunity to adduce evidence in respect of whether these three companies actually had a joint controlling interest. That's a point of evidence which is, on any view, open to you.
Let me perhaps come to the merits of that ground. The appellate today seems to be saying, my lord, that there was a controlling interest which ought to have been identified by the trial judge and by the Court of Appeal. But I come back to the issue, notwithstanding all the averments which were made by the respondent, and in that respect, perhaps I should take your lordship to the affidavit of Mr. Gallia on the 23rd of March 2009, which is at page 194, my lord. Your lordship will see paragraph 6D. I should perhaps start with paragraph 6B2.
No.
At page 195.
Yes, right, yes.
Paragraph 6D, paragraph 9A, paragraph 10A, paragraph 25, 27B, 28, 37.
If you're wanting us to note this,
I do
slow
apologize.
down.
I do apologize. Paragraph 25.
10A, 25,
27B,
Yep.
28, 37D,
Right.
and your Lordship will see at paragraph 42.2, where the point is made by Mr. Gallia that there must be a loss of controlling interest, having said that there was none.
Sorry, this is Mr. Gallia in when, some 2009,
That is correct, in March
giving
2009.
his interpretation of the agreement.
Well,
That is indeed the case.
he's putting his case forward, isn't he?
Yes, but is he contradicting the understanding expressed by the parties at the time, as we have it on page 156, paragraph 8, for example, as to what the parties at the time thought this agreement was about? I mean, obviously,
He was not privy to the discussion.
No.
It is not. It is
we
not
don't have any
disputed.
challenge. If it's relevant, and we'll come on to this, but if it's relevant to know what the parties at the time thought they were doing, then the only evidence we've got is paragraph 8 on page 156.
It is not disputed, Miro, that Mr. Gallia, in response to that, said, look, I deny without making any averment with respect
He
to
says,
what
well, look at the agreement, it's clear what it says.
Indeed,
I
indeed.
understand that. That's what you said.
The point I'm trying to make is that in the face of the averment made by Mr. Gallia, your Lordship will see in the affidavit of the 19th of June 2009, which came from the appellant, at no point in time, my lord, do the appellant give a response to Mr. Gallia when Mr. Gallia says, look, there was no controlling interest. And in that respect, I'm saying it is wholly unfair today, after the...
So they don't respond by alleging that there was a prior controlling shareholding interest.
Pardon me, Lord.
They don't respond.
Indeed,
saying
indeed, that is my
prior
point.
controlling interest. Yeah, that's the point.
Yes. So, now, what is also important, my learned friend referred to the submission of Mr. Sauzier. I would like to take your Lordship to the evidence submission of Mr. Sauzier, which is at page 442. Top of the page below. And that perhaps helps us to understand when the court said, well, why did the parties use the language which was so difficult to understand? If we go top of the page, submission of Mr. Sauzier, this is what he said. So we have been, according to this paragraph 57, they have been negotiating for a long time. They have been reducing it in writing, and the clause is a nonsense. The whole agreement is a nonsense because there was no controlling interest. This is the submission of Mr. Sauzier appearing for the company. So meaning that if Horus let us go along another path, if they have acquired 90% of the shares of UDL, we will be in the same situation. There would be no controlling interest because there was no control at the time they signed the document. This is not the intention of the parties. Fair enough. I'll deal with this. This
yes,
point.
I mean, he says change of control ultimately comes to the board, and there is a change. So,
And then the court.
That's the alternative case that's being, I mean, that case is still being put today. The new point is to suggest there was actually a controlling interest after all.
That's argument one. And at the moment you're addressing argument
Yes.
one and saying it
And you're
comes too
saying it's a
late.
new point, but it seems to
I'm
be
saying
clear.
that
It clearly is a new point.
It is a new point.
Yeah.
not only does it come too late,
But assume it is a new point, assume you've got that and it is a new point, well then obviously there's a question about whether you can take it or not. We can form a view on that. But I'm rather more interested in what you say about the original case. Anyway, you'll come on to that.
Carry on. I mean, you've got
Yeah.
a certain amount of time, and
So
let's...
what I'm saying is, following the remark made by Mr. Sauzier, then the court went on to say, so why do they use a language so difficult when it was so simple? In the sense that if the idea was purely and simply to prevent any change in the board, why did you use the language which you used?
Yes.
The judge was not saying, look, the clause was ambiguous or whatever. Now, my point is this, my lord. The case of United Docs was very clear right from the outset. At no point in time did the appellant respond to that case. The case was fought before the trial judge. The case went on appeal, and at no point in time was it suggested that there was a controlling interest. Now, let me come to this issue of controlling interest. Can I take your lordship to the clause 11? Now, it says 11.1.
Right.
It says, should there be any change in the shareholding structure of any of the parties resulting in the loss of the controlling interest of the shareholders, which
Page 74.
who currently hold such controlling interest in said party, the other parties shall have an option to purchase all or part of the shares of such party. You know, if the parties had remained there and had not deemed it appropriate to include a definition for controlling interest, one would have said, well, you know, there is some ambiguity with respect to clause 11.1. But the parties chose of themselves to include what I would call a definition, and they referred to the definition which is set out in the listing rule. And in the listing rule, we see that it says any person who is, the first part deals with a person who is the holder of 20% or more of the shares. But more importantly, the second part, one which is in a position to control the appointment and or removal of directors holding a majority of the voting right at board meeting on all or substantially all matters. Now, my learned friend has relied on the statement which was made by Mr. Rivalon in his affidavit to submit that on the basis of what Mr. Rivalon says, clearly there was a controlling interest at the time the agreement was signed, at the time of the acquisition. If we may go to the affidavit of Mr. Rivalon, my lord. Now, that is at page 154 of the brief.
It's 157, paragraph 13, I think, that you're founding on.
Now, I think it is appropriate to look at paragraph 8, where Mr. Rivalon speaks of the parties agreed to protect this preferred relationship by inserting clause 11, which forced the sale of the shares in the event that this relationship was disturbed by a raider or for some other reason, resulting in the change of control within any one of the parties. This change of control would result in a change of the persons at the helm of any one of UDL, Desmond, and Rivnu, and PIM, a situation which the parties did not wish to be placed in relation to the company. Paragraph 9, one before last, control and controlling interest on the board of UDL was and has always been throughout the discussion of paramount importance for Mr. Gallia and Mr. Mayor. This is what they sought to achieve and did in fact achieve in October 2006. Now we come to paragraph 13. It says, in fact, ORAS paid PAD, Anglo-Mauritius, some 2 or 4 million for the said shares in view of the exceptional weight of PAD and Anglo-Mauritius had in the voting at the members' meeting. ORAS knew that in purchasing these shares, it could take control of the board of directors of UDL. In view of the very low attendance of members at the AGM of UDL, PAD, Anglo-Mauritius, and La Prudence usually represented a very large majority and most substantial percentage of the members present and voting, and in fact had appointed the then board of directors. My submission to your lordship is this. When we go to the definition of controlling interest as set out in the listing rule, it clearly requires one which is in a position to control the appointment and or removal of directors holding majority of voting right at the board. The intention of the parties was clearly either solely or jointly you were in a position to control the appointment. It is not disputed that by virtue of the Companies Act of Mauritius, to secure the appointment of the directors, one has to have at least 51% of the shares of the company. So the
51% of the voting shares,
of the voting
shares which actually vote.
Indeed. So that when reference was made by the appellant to the listing rule, clearly when it speaks of one which is in a position to control the appointment and removal, what they had in mind, just as those who formulated the listing rule had, was did the person solely or jointly had the power to appoint the directors? Now, in this case, Mr. Rivalon is saying that because of the low turnout at the shareholders' meeting, over the years, PAD, Anglo-Mauritius, and La Prudence have been able to secure some kind of majority. My submission is this is neither here nor there, because that was not the intention behind the definition of controlling interest as set out in the listing rule. So my submission, therefore, is that to the extent that the appellant is saying today that, well, on the basis of paragraph 13, there was clearly evidence of a controlling interest, my submission is that that cannot be correct, because the formulation of that definition cannot depend on the attendance of the members. And here I perhaps need to add, if your lordships go to page 141 of the affidavit of Mr. Gallia. Mr. Gallia said that at the meeting of October 2006, a majority of 67 to 74% voted in favor of the new board. So that we were not dealing with a situation whereby there was a low turnout and Horus and La Prudence, for instance, were able to secure the appointment of their directors. My submission is that to the extent that the appellant today seeks to rely on paragraph 13 of the affidavit of Mr. Rivalon to argue that there was a controlling interest, my humble submission is that that cannot be correct, that was not the intention, and that is against the word of the listing rule.
Actually, it occurs to me to wonder whether perhaps we should have pursued with Mr. Moulin a little more the question, even after the takeover, was Horus really in a position to control the appointment and or removal of directors holding a majority of voting rights at board meetings, simply because it acquired an additional 18%, giving it a total of 25%? The reality is it had to conduct quite a heavy battle before it persuaded a lot of other shareholders in October that in fact their financial interests were best served in by voting for a change of the board.
I thought this wasn't an issue.
Well, I'm just wondering.
Well, you know, we've got.
No, what is it?
What
is an issue? What is common ground is that, as I understand it, is that Horus became, as a result of the resolution in October, the parent company. But that doesn't mean to say that from July. Anyway, maybe it is not an issue, but
and that's why we referred to the accounts, page 323.
No, but that's a different point. The fact that once it had acquired control of the board, it was the parent company, and had to account for it as in group accounts, is one thing. The question whether from July on it was able to control the appointment, that was for the birds. That was a matter for hefty argument and for persuading other shareholders. So, I mean, anyway,
it's not by October it was. It doesn't matter whether it was in July.
No, because the question is, we're arguing now whether in July it became.
You know, what matters what was the position beforehand.
This reminds me of three observations which I perhaps need to make. Firstly, I believe my learned friend may not have traced the evidence which shows that for 20 years there has been the same management. I have tried to look for this, I have not. The second point is, with respect to Horus and La Prudence, Your Lordship would have noted that in the affidavit of Mr. Gallia, he says, I own only 22% of La Prudence. There are other shareholders, that is true. Third point, which perhaps...
But he controlled La Prudence with his 22%, didn't he?
In the affidavit, he seems to say that, well, he's not the only shareholder of La Prudence.
But he'd fall within the listing rule definition.
Yeah.
Yeah, he controls it within the listing definition.
Yeah.
The third point, perhaps, which Your Lordship need to bear in mind is that Mr. Gallia is not the controlling shareholder in Horus, because Horus is composed of two shareholders, Mr. Gallia and Harel Frère, each of whom owns 50%. So these are observations, perhaps, which were important to make to Your Lordship. But more importantly, when we come to the statement of Mr. Rivalan, there has been no evidence adduced before the lower court, and Your Lordship is fully alive of the evidence which was before the court. There has been no evidence to show that La Prudence, Anglo-Mauritius, and the third shareholder, and UDL, PAD, Anglo-Mauritius, and La Prudence had acted in concert with a view to control the composition of the board. There is no evidence in that respect. So this is why I say, to the extent that we had evidence to the effect that one controlled or jointly they had control by virtue of the fact that they were acting in concert, fair enough, but there was no such evidence. So my submission to Your Lordship is that to the extent that the appellate relies on paragraph 13, my submission is that it's clearly too vague for Your Lordship to reach the conclusion that on the basis of paragraph 13, it can be said that there was a controlling interest.
Will the listing rules, when they're made available to us, clarify what, if any, requirements there are for concert if two or more shareholders are to be treated as being in control?
I am advised that this issue is taken up in the takeover rule and not in the listing rule. But we will favour Your Lordship.
Takeover code.
The takeover code.
Yes, well, one imagines it's taken up somewhere.
Yes, but
It's rather
but
important.
if there is information on that, I'd welcome it being submitted in writing.
I think Your Lordship asked the question with respect to the pertinence of the definition of controlling interest. I understand that that definition finds its importance in relation with disclosure requirement.
Yes.
But Your Lordship...
Yes, well, then it's equally important in that context whether you have to act in concert, isn't it?
Yes.
I imagine the two are linked, aren't they? The disclosure and the takeover requirements, one would expect them to be in parallel.
Yeah.
Yeah. But I mean, it would be very useful, I think, to see what the takeover code says about it. But your point is that whatever it says, it isn't satisfied by paragraph 13.
That is
Yes.
the case.
Precisely.
You know, may I move on to the issue of the argument of my learned friend that to the extent that the intention of the parties are not reflected, if I may say, in the words of the contract, the court should give effect to the intention. Now, with respect to the argument of my learned friend in law, I do not differ insofar as French law is concerned, in the sense that clearly I agree with my learned friend that what the court are concerned with is to determine what was the intention of the parties. First and foremost, my submission is that the court should have regard to the contract. To the extent that the contract is clear, the need to go to extrinsic material in my humble submission doesn't arise.
Is that right? I mean, we've got these extracts in his appendix from various learned texts and from various judgments. And for example, at the bottom of page 4, the judge may discard the terms used by the parties if it is, sorry, this is an extract from the J.S. Rabot case, Statement of Law from the Delors, page 4. The judge may discard the terms used if it is established that despite their clarity, the terms relied upon, taking their literal sense, were incompatible with the contract as a whole and the obvious intent of the parties.
I will
So
come to this.
one doesn't stop at the clear words.
Yeah.
One actually, if one's got evidence that the intention was different, then one has to think again,
Now,
which is a sort of probably not
think-
the English position.
I would wish to take your lordship to paragraph 50, 51, 52, 53, 56 of the statement of case of my learned friend, where the point is made that to the extent that the contract does not reflect the intention of the parties, then the court in England would have proceeded by way of rectification, but in France, there is an interpretation which is given which is consonant with the intention of the parties. Now, your lordship will see that in all the authorities referred to by my learned friend, if I start at paragraph 50, there is no problem whatsoever with dénaturation in a case of erreur bilatérale. My learned friend is relying on mistake. If we go on the next page, à la condition, top of the page, à la condition que l'erreur commune des parties soit établie, les juges
Sorry,
du
I'm not
fond.
with you.
I'm sorry.
Which page are we on?
On page 29.
39.
Submission
29.
of the statement of case of my learned friend.
Yes, that's in English.
Translation.
29 paragraph, page 29 paragraph
Paragraph 50, my lord.
50. It's up.
Top of the page.
Top of 50.
If I may refer to the English submission of my learned friend. In other words, the factual exercise of looking for the real intent of the parties must be carried out in all cases where it is alleged that an error has occurred.
Yes.
So, my submission to your lordship will be that, look, to the extent that we're saying there has been mistake in the sense that the words do not actually reflect the intention of the parties, I have no quarrel with my learned friend, that in those circumstances, as opposed to what would be done in England by way of rectification, the French would proceed by way of rectification. Now, let's go to paragraph 52. My learned friend cites two cases, case of Harpal and Prayac, where your lordship would have seen that we were clearly dealing with the case of mistake. On the next page, paragraph 56, page 31, paragraph 56, my learned friend refers to two French authorities. Les parties ont commis une erreur sur le sens d'un terme. Further down, lorsque les deux parties à l'acte ont été dans l'erreur. My submission to your lordship will be this. We agree that to the extent that the words of the contract do not reflect the intention of the parties, and it is claimed that there has been mistake. In those circumstances, in England there would be a rectification. In France or Mauritius, there would be an interpretation which is in line with the intention of the parties. But the point is this: at no point in time did the appellant come forward to tell the court, look, there has been mistake.
But there is. I mean, surely the whole point of paragraph 8 is to say that what we thought we were entering into was an agreement where a change of control or change of the person at the helm of any one of UDL, SMM, Rivnu and PM would be a situation in which there would be a trigger in clause 11. Now, if you're right on the interpretation of clause 11, they made a mistake. It clearly didn't, because it didn't apply to UDL, because there wasn't anyone in control of UDL. Yeah. Now, Why is that not a mistake which then brings you into the
My-
realm of these provisions?
My point is this. I submit, I would like to think that be it in the English law or Mauritius law, the rules of pleading would have it that you must, at the very least, apprise the other side of the fact that you are relying on a case of mistake. That has got some important implication under Mauritius law. If mistake had been pleaded, the parties would not have been entitled to proceed by way of motion plus affidavit, my lord, because then there would have been a controversy with respect to the evidence. If mistake had been the case of the appellant, they would have had to proceed by way of plaint with summons. Viva voce evidence would have had to be adduced. That evidence would have been challenged in the course of cross-examination. But more importantly, if I may take your lordship to the authority of our panel,
The mistake has got to be evidenced by external, it's got to be exteriorized, hasn't it, according to the annex to the appellant's submissions at page 5. A judge can't give effect to the real will unless it is in some manner, in whatever manner, exteriorisé.
Is there?
Exteriorised. That, in other words, the same principle as rectification in English law. You have to find, that's about 12 lines down the page. Yes.
no,
So, I mean, that's another point. Anyway, sorry, I'm taking off your course.
I was, I would like to refer your lordship to
Expressions of some...
tab 11, our PAL. The lordship will see
Tab 11, yes.
middle of the
Harple.
second half of the page. D'une part, appliquant l'article 1341, elle ne permet pas de faire la preuve d'une volonté réelle différente à la volonté exprimée par écrit.
Sorry, where are you?
I am at page 754,
Yes. How far down?
tab 11.
Yeah. On which bit were you reading? First, second, third, fourth, or which paragraph of the French?
I'm reading from third paragraph from bottom, my lord.
Yep.
D'une part.
Ah, yes. Third from the bottom.
Is this a footnote or is this... No, no.
No, it's a quote from...
Can I just, for the benefit of your
Daniel
lordship,
Leary.
file the translated version of
Yep.
Article 1341?
Oh, there's something about third parties here as well.
That's of the Code Civil, is it?
I understand that this has already been filed in the course of a recess, an extract from the Code Civil, my lord. There is a translation of Article 1341. It's R16, my lord.
Coming around.
It's just coming now.
Thanks.
Oh, I've got two.
Like Algiers.
Thank you.
Thank you.
1341.
Right.
The point I was making is
Yes.
What are we looking at here?
1341, do you want us to look at?
1341.
Testimonial proof.
Indeed. In the event that a mistake had been averred, and that was the cause of action which had been raised by the appellant would have been bound to proceed by way of plaint with summons.
Right.
Viva voce evidence would have had to be assured. That evidence would have been challenged. But your lordship will see that by virtue of Article 1341, one would not have been able to adduce oral evidence, outre compte, contrary to the content of the contract, unless there was what is called a commencement de preuve par écrit. In other words, there was evidence in writing which tends to contradict the contract. Right? Now,
I'm terribly sorry, Monsieur Person. I'm lost. It's my fault. I'm miles behind. I'm trying to see why Article 1341 has got anything at all to do with this.
My submission is this, my lord.
What it's about.
To the extent that it had been averred that, well, there has been mistake in relation with this contract. My point is that the plaintiff would have had to adduce viva voce evidence. Now, they would not have been able to adduce evidence.
Article 1341 doesn't seem to be about a mistake at all.
Indeed.
Well, except when you read it in conjunction with page 754, it seems to be interpreted according to Planiol and Repair
Yes,
in a particular way.
that's what I don't understand.
What the judges in the case of Harpal were saying is that one has to bear in mind the provisions of Article 1341, which limits the admissibility of oral evidence contrary to the content of the contract. So
You see, all this is premised on what you're trying to do is to force the case against you into the box marked mistake. I mean, the case we're in at tab 11 is the case about the plot of land which had the wrong number ascribed to it. That one can see as a mistake. But the kind of error, to use a neutral word, which is said to have been made here, isn't a mistake of fact. It's a mistake of drafting.
I wonder about that. It was presented as being a mistaken assumption of fact, and I noted that the use of the word loss was on the assumption that there was a controlling interest.
In those circumstances, let me take your lordship then to page 9 of the brief, paragraph 13.
This is
The
record page 13.
Page 9 of which?
Some of us are a bit lost over here. What page are we on?
Page 9
Of the main bundle.
my lord, of the record, paragraph 13.
Paragraph.
The record.
Right.
The point is this. I mean, at paragraph 13, the appellant's affidavit would have it. There is a reference to clause 11. And then the next sentence is, for avoidance of doubt, clause 11.2 of the agreement state that this expression controlling interest shall be interpreted as the interest held by a controlling shareholder as per the listing rule. I mean, how can one today say that, there was mistake in relation with clause 11.1 or 11.2, when the case right from the outset of the appellant was that, look, the clause 11.2 was precisely inserted with a view to clarify matters. Let me also take your lordship to the submission which was made by Mr. Ribot at page 443. Mr. Ribot appeared for the appellant. Now,
Who was Mr. Sozier for? He was
Mr. Sozier appeared for the company Access,
for the company.
and Mr. Ribot appeared for the appellant.
Mr. Ariba was the opponent.
Now,
So where
Nine.
are we on? Where page?
Page 443.
page 443, Mr. Ribot.
Yeah.
Mr. Ribot replies, top of the page, my lord.
Yeah.
Can I just answer in order to trying to clear definition? I have 2 points to make. The objective of 11 as it appears in the share agreement at page 52. The clause 11.1 have to be read in my submission with 11.2. 11.1 says what is what it is. 11.2 says that controlling interest shall be interpreted as the interest held by the controlling shareholder. This is where we go then to the listing rule and to see the definition of controlling shareholder. And my learned friend dealt on that definition, which I take it is the standard definition in most jurisdictions. Now, if I may take your lordship to the bottom of the page, last paragraph, first line, so that I submit that this phrase is still important in our case, if it can be viewed in the sense that I am submitting that it is. It caters, therefore, for the situation where there is not only more than one director being involved in that controlling power, but more than 50% usually. It does happen, therefore, that in the normal board, one director is one vote. It indicates simply that if out of 10 directors I demonstrate that I hold power to appoint or remove more than 5 directors out of the 10 directors, then I fall in that third definition. The point I was trying to make, my lord, is that as opposed to saying that there was confusion, there was an error, there was mistake in relation with clause 11.1, we see that the parties themselves in the affidavit made it clear that 11.2 was precisely inserted with a view to clarify 11.1, so that the submission which is made today to the effect that there would have been mistake on the part of the parties, in my humble submission, cannot stand. Now,
I mean, insofar as there is evidence of a mistake, in the light of the way the case was conducted below, it might be said to be a mistake in thinking that Clause 11 would apply to a simple change of directors.
but then.
But it doesn't, you say. Yeah. Anyway, carry on.
But this is not how Clause 11.2 is to be read, my lord, with respect.
You know, controlling interest is a controlling interest in terms of shareholder power.
Yeah. I think the trouble is you don't pick that up perhaps by reading the clause 11.1 and 2 by itself, because you have to go to the listing definition before you fully understand that. Anyway.
My lord, if I may perhaps go to the submission made by the respondent I'm referring to the case for the respondent at paragraph 47, the issue of attendance. I have already addressed your lordship that the question of controlling interest cannot be dependent on the question of attendance. At paragraph 48, we made the point with respect to the use of the word for the avoidance of doubt. Now, I would like to take your lordship to the arguments which we make at paragraph 54. That is a point which was taken by my learned friend in relation with the pertinence of clause 10 in interpreting clause 11. Now, we indeed in the court, before the Court of Appeal, referred the court to clause 1.2.6. Now, I would like to perhaps take your lordship to that specific clause.
Isn't it quoted there?
Page 60, my lord.
60.
It's quoted on page 20, paragraph 54, isn't it? The document we were just looking at.
I'm reading from the shareholders' agreement itself, my lord.
So we don't need
It says, each and every provision of this agreement and each and every part thereof shall, unless the context otherwise necessarily requires, be read and construed as a separate and severable provision, and as separate and severable parts thereof, so that if any provision or part thereof shall be void or otherwise unenforceable for any reason whatsoever, then such provision or part thereof, as the case may be, shall not only be severed, but the remainder shall be read and construed as if the severed provision or part thereof was omitted therefrom. My submission is that I reiterate the submission made before the court below. I think the clause does two things. Firstly, it clearly says that each provision shall be read separately. But then, secondly, there is also...
It doesn't say that at all. It said it would be read as a separate and severable provision.
Indeed.
And the only thing that is the only things that are construed as if there weren't provisions there are the provisions that remain after the severance has occurred. So what it's saying is that you read in accordance with normal contractual rules, unless something is severed, and if it is severed, you read it as if that thing wasn't there. So I, for one, will take a lot of persuading that 126 has anything to do with this.
I mean, are you literally inviting us to treat Clause 11.1 as entirely severable? Well, presumably even from Clause 11.2, read it in the air. And they must be read together.
No, I'm saying with respect to 10...
And they must be read in the context of the agreement.
With respect to 10 and 11, I think the distinction ought to be made. But,
so we can read sub-clauses together, but we can't read them, even though they're separate provisions. But surely we can read them in the context of the whole agreement, can't we? This is dealing with a different thing. This is dealing with...
You see why the point is made, don't you? Because they say, rightly or wrongly, but you need to deal with it, that once you put 11 alongside 10, unless you read 11 the way they want, you might just as well not have 10. Because anybody can get round 10 by changing the control of one of the shareholding companies. That's what they say. Now, what's wrong with that?
But then, I said 11.1 ought to be read in the light of 11.2, which clearly requires specific requirement. There are specific provisions which ought to be met before 11.1 kicks in. Yes. So, my submission is that one cannot ignore the provisions of 11.2 in interpreting 11.1.
I see.
But does it make much sense? I mean, isn't there a loophole? Yeah. You intend to prevent yourself being faced with a new controller of one of your shareholder partners. You intend to do that clearly if there is an existing controller, but what you're worried about is the identity of the new controller. Why does it make any difference if there isn't an existing controller? You ought to be logically equally worried about some new controlling individual coming on the scene and superseding all the individuals who previously had shares in the company. On your interpretation, there's a bit of a loophole in this protection, isn't there? That's the point. And the Clause 10 is invoked in this connection, showing how keen they were on protecting the closed relationship.
Well, I don't know if that helps your lordship, but we were here dealing with United Dock Limited, which was a listed company. To the extent that Mr. Rivalon says, you know, we trusted those who were on the board of United Dock. Mr. Rivalon ought to have borne in mind that to the extent we were dealing with a listed company, those who were sitting on the board could be removed at any time. So that is something which ought to have been borne in mind, not only by Mr. Rivalon.
You mean without any change in the shareholding, if the existing shareholders got fed up because the earnings were half what they were 5 years before, they could just boot out the board, and then it'd be completely new faces, people at the helm. Yeah.
Yes. So, on that view, these sort of clauses aren't very suitable for shareholder agreements involving listed companies.
We're told that this is an absolute boilerplate clause and is found in hundreds of agreements. So it's not really part of the trouble. Maybe it's not tailor-made for this situation. It's just hoist out of some form.
Your Lordship.
And that's said to be the position in one of the, I think in, maybe it's in the statement of facts and issues, but it's certainly said somewhere.
Do you agree with that as a matter of interest? Do you agree with that as a matter of interest, that this is a very common form of clause?
I wouldn't say it's common, because Your Lordship would have noted that I took objection to the validity of the clause to the extent that we were dealing here with a listed company. Of course, there was a ruling against me by the trial judge which found that there was nothing inappropriate in what I call a poison pill. So,
I think also the comment about it being a common clause, it was tied in with termination of employment contracts as well. So I think it's a clause of this sort of nature.
Yes,
is a common clause,
well, where do
rather
we...
than the precise wording of clause 11.
Yeah. Right. So no idea whether this was drafted to meet this agreement or was just hiked in from some other form.
now, just one last observation. I think my learned friend referred to page 818 of tab 18 this morning, the authorities, Milan. Tab 18.
Yeah.
The reference to Juris Classer at page, I think, at paragraph 40, as Your Lordship perhaps rightly observed, to the extent that it says aussi imparfaite que soit le langage comme véhicule de la pensée, si la formulation est claire et dénuée d'ambiguïté, elle doit être tenue pour exacte pour des raisons évidentes de sécurité du commerce juridique. Telle est la justification du contrôle par la Cour de cassation de la dénaturation des clauses claires et précises. My submission is that when it comes to clause 11.1, I think the trial court came to the conclusion that the clause was clear and precise. That was a finding which was agreed to by the Court of Appeal. And in that respect, my humble submission is that to the extent that the trial court found that the clause was clear and unambiguous, my submission is that it was clearly appropriate that the judge should give effect to the clause as worded. You know, these are my submission, unless my learned friend would wish to add to what I have submitted.
Do you have a copy of Article 1321 of the Mauritian Code, by any chance?
41?
21.
21.
Is it the same as the French code?
The reason I ask is that I want to understand the extent to which one has the second stage of interpretation on which the appellant is founding and which I think you accept can exist. And I think there was in the Harpad case, the case about the
Land.
areas of land, that was tab
11 or 12, one or the other.
11, Harpal. Yes, it's just that in page MS 754, towards the bottom of the page, the third last paragraph says, d'autre part, appliquant extensivement l'article 1321, Code civil qui interdit aux auteurs d'une simulation déposée au tiers un acte secret, il fait prévaloir la volonté déclarée sur la volonté réelle quand il s'agit de protéger les tiers. Is that a principle? Is that the principle that protects third parties from stage 2 of the contract, the contractual interpretation?
What it says, it says les contre-lettres
That deals with contre-let,
I assume that means side letters.
side letters.
Les contre-lettres ne peuvent avoir leur effet contre les parties contractantes. Elles n'ont point d'effet contre les tiers. May only have their effect against the contracting parties. They don't have any
Not
effect against third parties.
That is indeed the case.
So that may not help.
Because they're secret.
Yeah.
Now, one last point, my Lord, with respect to the principles of interpretation,
Yeah.
which I believe might be of some relevance. We have caused to be in R14.
Broadly.
Just a moment, wait a minute. What page is this on?
This is 1321.
No, yes.
Point. It's 754, because what they're saying is applying Article 1321 broadly, there seems to be a principle that that you can't use against third parties as a secret act. It's necessary to give precedence to the declared intention over the real intention when it's necessary to protect third parties.
And 1341 also seems to be quite radical according to this, but is there anything to amplify what is said about on page 754? We got planiol and repair, droit civil français. Or we just got this quote from it.
Perhaps to try to help you.
Page 754 in tab 11.
Yeah.
There's a quote in the middle of a judgment from a
Planiol.
work by Planiol and Repair, and you'll see near the bottom, you referred us to the third from last, which refers to Article 1341, and the second from last refers to 1321.
Correct.
And they seem to be significant restrictions on the operation of the principle that you look at the real will as opposed to the expressed will.
Yes, they're introduced. If you look at the paragraph that's under the dotted line,
Yes.
and at the last sentence of that, that introduces the next two paragraphs, and it says, which is French law, assouplit la théorie de la volonté par les moyens suivants. Now, am I right in my bad French in reading that as meaning, but there are qualifications?
By the following means.
Yes, qualifications via the following means.
Yes.
The next one's just about is drawing a distinction between wishes expressed in writing and wishes expressed orally.
Which is what 1341 does.
That's the limited effect of it, it would appear.
1341 is about when you need a notarized act in writing. Is that right or not?
I think it covers all. Where have we got
And
1341?
it doesn't have to be notarized. It's in this most recent.
These are
We actually got the
It's R16.
it's the new document.
new document, yes.
We've only got the translation.
R16.
Yes, because according to Planiol and Repair, that statement at 754 is applying Article 1341, while as far as Article 1321 is concerned, there is an extensive interpretation given, appliquant extensivement.
I'm just wondering if 1341's got anything to do with it. Where does it fit in? It follows a section headed Acts of Recognition and Acts of Confirmation, just ahead of 1337. Is it gifts?
It's about all wishes, sure.
It looks like proof. I may be quite wrong, but it rather looks like proof of unilateral acts, but it may not be.
No.
Good.
I think it means you have to enact, you have to agree either before a notary or
underhand.
private signature, yes, under all cases exceeding a certain sum or a value fixed by decree, even voluntary gifts, I think.
Yeah.
And there shall not be received any proof by witnesses contrary or outside the content of the acts.
Right.
So that means that it must include acts, private acts under signature. Well, is this that sort of act? It's not really, is it? Perhaps it is. Yes, it's an agreement. Yes.
But there's another sentence. All of this is without prejudice to what is prescribed in the statutes relating to commerce.
Yes.
Yes.
My Lord,
Be alleged to have been said before, during, or since such acts, even when you're concerned with a sum of a lesser value than that fixed by the decree. It seems to be. This doesn't apply
I
to
don't think they're very...
trade matters.
Speaking for myself, I need a great deal more information in this.
the pertinence of this article, which I referred to earlier, I mean, this brings me to the argument I made with respect to the credibility with respect to the point raised about mistake. My point was that this was something which was not pleaded. Had it been pleaded, Article 1341 would have been relevant with respect to evidence being adduced outre et contre the content of the
I see. You're simply
of the
saying you
contract.
would have relied on Article 1341, whatever it means,
So what would you have relied upon it to say?
what to deal with the.
Well, you don't know because you haven't looked at it.
To deal with the suggestion that you could look at evidence outside the agreement.
Now, the last article on which I perhaps would wish to draw your lordship's attention.
Sorry, why would you have relied? Help the Lord Clerk.
I'm saying, my Lord, that the claim of mistake is something which has arisen only before your lordship. It was not taken at the trial court. Had it been taken, then the appellate would have been debarred from adducing oral evidence with respect to the intention of the parties until and unless there was what is called a commencement de preuve par écrit, in the sense that there was a document tending to show that the parties' intention was other than that expressed in the agreement. But to the extent that the point of mistake was never taken, the respondent was not in a position to challenge that evidence. As I said, the case which was before his lordship in Mauritius was purely and simply an interpretation of clause 11.1 and 11.2. It was never suggested that there was a mistake with respect to the intention of the parties, that the clause did not actually reflect the intention of the parties. And the point about 1341 is precisely this. Had the point been taken, then there would have been objection to viva voce evidence being ushered against the content of the contract. Now, finally, I would like to refer your lordship to Article 1162, my lord, of the Code Civil, which is at R14. The translation is at R12, where your lordship will see that I'm reading it from R12. In case of doubt, an agreement is...
Sorry, let's just find it. 1162.
1162.
Contra proferentum.
Yes.
Indeed, the contra proferentum rule, to the extent that there is any ambiguity. An agreement is interpreted against the party who has stipulated and in favor of the party who has contracted.
I can't find it.
Yes, here we are. It's on this page.
It's on that page, is it?
Now, at the end of the day, if in the claim of the appellant that there was an ambiguity with respect to the clause, my submission is that then the trial court would have been entitled to interpret the clause against the party stipulating. But in this case, in any event, as I said, the trial court and the Court of Appeal had reached the conclusion that reading clause 11.1 and reading 11.2, there was no ambiguity.
You can't make contra proferentum work if the clause was devised by both the parties that you're speaking of. And this one was devised by both UDL and the present appellants.
Your point being that it was a standard form contract.
Yes.
To which UDL was adhering to.
But I
Right?
suppose
I get your
you might
point.
say that since it deprives someone of their property,
But
Yes, that's different.
that's a better word, well, possibly
Yes.
a better way of putting it. It shouldn't be construed generously.
Well, that's the third party point, yeah.
let me end my submission by saying, my Lord, in any event, I think the trial court reached the conclusion that the clause was clear. The Court of Appeal reached the conclusion that to the extent that it was clear, it would not be appropriate for us to distort, not to use the term dénature, the nature of the clause. In my humble submission, the Court of Appeal was clearly right in not departing from the clear words of of clause 11.1.
So your submission, your argument,
Yes, my Lord.
your argument in the court below was this is a clear contract and you can't go beyond it because there's no need.
Indeed.
Is that right?
Indeed, my Lord.
Yes.
The intention of the parties were clearly expressed in both clauses 11.1 and 11.2.
I see. And that's what you got.
Do we have a copy of that argument?
Say.
Do we have a copy of your argument, of that argument?
I think
It's-
yes.
Yes. And indeed, it's reflected in the conclusions of both the trial judge and the Court of Appeal. The argument against you is that it doesn't ask the right question.
You know, these are my submission. Unless your Lordship wish me to address on any other specific issue.
Well, could one argue that, just looking at clause 11.1, should there be any change in the shareholding structure of any of the parties resulting in the loss of the controlling interest of the shareholders who currently hold such controlling interest in the said party, in a situation where there is no controlling interest in any one group, could one say that this must apply to all the shareholders and the controlling interest must be treated as spread across all the shareholders? I suppose you say that's inconsistent with the listing agreement.
Yeah.
The definition, which but they did all have the power, didn't they, at that stage, to appoint directors, looking at them comprehensively.
So there weren't different classes of shareholder in terms of voting rights in UDT? Is that the...
Yes, I mean the power to appoint the shareholders was the directors was simply spread across all the shareholders. I suppose that the trouble is that means that Horace, when it effectively acquired 18%, would on one view get a controlling interest, but in another view, all the shareholders would still hold the controlling interest. It
Yes.
doesn't really work, perhaps. Anyway, it's not there's nothing you want to say on that, probably. Hasn't been floated, I think, as an idea. Right. No. Mr. Laumamode? No, thank you very much. Yes, Mr. Milren.
If I may, I will come back to the earlier points made, but I would like to start by clearing up the confusion that has arisen regarding Articles 1321, 1341, etc. The first point I would make is that when one is looking at error in the context of the exercise of interpretation, one is not dealing with a cause of action for mistake. It is part and parcel of the process of interpretation. Now, if you look, please, at what was said in Harpal and Prayag at page 754 of the authorities bundle. First, there is reference to Article 1341, and because we received a copy of that article on Friday, what we have done is we have prepared a small bundle of responsive authorities on a point that wasn't taken before, which explain to you exactly what 1341 is about. But before turning to that, if I can just deal with the two other points made there. Article 1321 is talking about simulation. It's got
21 or 41?
so starting, I'll turn to 41 in more detail.
21, that's fine.
21. 21 is dealing with simulation. It's dealing with dissimulation of an act. It doesn't have any application here.
I wonder about that, sorry.
No, go on. I've got 1321, les contre-lettres ne peuvent avoir l'effet contre les parties contractantes.
Yeah, a contre-lettre, as it's said here, interdit aux auteurs d'une simulation in the text of the judgment d'opposer au tiers un acte secret. Elle fait prévaloir la volonté déclarée sur la volonté réelle quand il s'agit de protéger les tiers. So this is the situation where you have a... I'm referring to Harpal and Prayag at page 754.
Okay.
The situation dealt with there is when you have a contract which says something, and then you have a hidden, dissimulated, concealed side letter.
Side letter.
And that's not opposable to third parties. That's all that article does. No more, no less.
Well, is that what Plagnol and Ripper are saying? They're saying you apply it generally and
Yes, applying extensively, yes.
extensively,
No,
yes.
If the extrinsic evidence you're trying to lead is a hidden side letter, you can't rely on that. That's all Article 1321 is doing.
Well, I wonder if that's what Plagnol and Ripper are saying. In that passage, they seem to be saying quite a bit more.
If you would like written submissions on the point, then we will give you written submissions.
Would rather, I think, have a copy of Plagnol et Ripper.
Well, Plagnol and Ripper is 60 years old, my lord, with respect.
Is it?
We could also give you Colin Capitan, which is 80 years old, but we'll try and give you more relevant.
What's the date of this case?
Then you have the question.
1969, that's 40 years old.
And then you've got the third point, which is, enfin, une déclaration de volonté contraire à la volonté réelle peut constituer une faute. These are cases of unilateral mistake, so it doesn't apply here either. Now, if we can turn to Article 1341. 1341 is very well known. It's about la preuve testimoniale. And it's full of exceptions. And I'm going to show it to you. And as my learned friend, with respect, knows very well, it has
Wait a minute, you can't, I don't think you should make that sort of...
I'm not, my lord. I'm not. I withdraw. But it has no application in commercial matters. And so there are three responses to the point on Article 1341. First, it doesn't prevent reliance on evidence to interpret a contract. Secondly, it does not even apply to the shareholders' agreement because the parties here are commerçants. This cannot be disputed. This case is between commercial companies engaged in investment business and proceeded before the commercial division of the Supreme Court. If you look, we're going to hand out a small bundle which just has the usual authorities on 1341. And in particular, it has 1341 of the Mauritian Civil Code, because what you have been given is 1341 of the French Civil Code. The distinction is that the Mauritian version sets financial limits in its body. It doesn't refer to an amount set by decree. So you have the text of Article 31 under the first tab. And the first point, therefore, is that it simply doesn't apply to prevent evidence being relied upon for the purposes of interpretation of a written contract. It applies where the parties disagree about the existence of a contract or the existence of an essential requirement for the validity of the contract, that is the existence, for example, of a purchase price for a sale. And we can take that most easily from Vogenauer, which is in the existing authorities bundle, page 9 to 8. And it's the first full paragraph, or the paragraph starting on the page, Article 13411 Code Civil. Therefore, like the parole evidence rule, prohibits the admission of extrinsic evidence for the purpose of varying or contradicting a written document. It differs from the English rule, though, in that it is not regarded as a substantive rule of interpretation. It only concerns proof of the existence of a contractual obligation, i.e., that the contract has been concluded in the first place. If the parties disagree about an essential requirement for the validity of the contract, for instance, the purchase price, 1341 excludes evidence inconsistent with the writing. But as long as the existence of the contract is not contested, and the parties only disagree about the extent of their contractual obligations because the terms of the contract are in need of interpretation, the rule does not prohibit extrinsic evidence from being adduced for this purpose. And I draw your attention also, is the next point I'm going to be making, at the last sentence of the next paragraph. Most importantly, all contracts governed by commercial law can be proved by any means. 1341(2). Yeah. You can take the same point from the French materials in the bundle. I will simply give you the references. Professor Simler, look please at page 812, paragraph 30. 31 in the other similar authority, tab 19, page 870, paragraph 54. So in other words, the question of the application of Article 1341, as you will see when you look at similar, has been looked at by the French courts together with the principle of denaturation. They go hand in hand because, as you saw, the court says, well, if it's clear and precise and there is no evidence of an error, then you stop there. But if it isn't, then you're entitled to look at and use the evidence. And as we have already submitted, my lords, Principle 6 in our list of principles, there is no question of denaturation where extrinsic evidence is relied on to show a common mistake, not unilateral, common mistake between all the parties, in the wording of the contract in order to bring the volonté exprimée in line with the volonté réelle. Now the second point, my lord, so that's interpretation. The second point is that it doesn't apply between commerçants. I've shown you Vogenauer. You will please look in the bundle that we've given you at the closing words of Article 1341, which expressly says le tout sans préjudice de ce qui est prescrit dans les lois relatives au commerce. We've also given you, behind tab 2, Article 109 of the Code de commerce. À l'égard des commerçants, les actes de commerce peuvent se prouver par tout moyen. We've given you an authority, Ibrahim and Padayachi, which is early Mauritian authority for the proposition that Article 1341 does not apply in a commercial matter. We've also given you, under the next tab, Société Alec, holding that Article 109 of the Code de commerce was intended to reflect the decision of the Cour de cassation, which held that courts, which had to make findings, in fact, en matière commerciale, could use any methods of proof established by law, and I draw your attention to paragraph 35.
Would the Code de commerce apply to this agreement, the one we're talking about in this case?
Yes, ma'am.
Would it?
So what's the Code de commerce say about?
It's not as it were, a contract of sale or a carriage of ship by ship or anything.
No, but the general provision that
Business contract, yes.
Yes, that it is an acte de commerce between commerçants.
Right.
Then we've given you Houdin, juriste classeur, fascicule 30, which also says specifically, and I quote, entre commerçants, par conséquent, la preuve contre et outre le contenu des actes écrits est en principe libre.
So that was the last tab, was it?
That's the last tab.
And which paragraph? Oh, yes, but it's penultimate, yeah, entre commerçants par conséquent.
Yeah, thank you. So, Lord, with respect, we say this is not a good point. And if and insofar as you were to require a commencement de preuve par écrit, because that is all that Article 1341 tells you, before you can go to testimonial proof, you need some document which shows that there might be an ambiguity, there might be something. And if you read Simler, you will see it's explained that because the contract itself is in need of interpretation, that's enough. But you've also got the board meeting I showed you from May. My Lords, that's just on that point. If I can go back briefly in the time I've left on the other points made by my learned friend. It is said by my learned friend that right from the beginning, the injunction, from the injunction application, the focus of the appellants was at all times on the change in the board of directors. Lords, I have given you the references to the passages in the evidence, in the record, which show clearly that from day one, both points were being pursued, both the change in July and the change in October 2006. You've got the judgment of Mrs. Justice Chong, page 185 of the record. You've got an argument by my learned friend himself in the Court of Appeal at page 429. And importantly, you've got the two letters of December 2006 triggering, saying that the option has been triggered. They rely on the July event and the October event. These are pages 88 and 89. Now, my learned friend referred to the cause of action being different. With respect, there is no question here of any change cause of action. This is an action for breach of contract. And as I say, in any event, the point was taken from the beginning that the facts relied on were both the July 2006 event and the October 2006 event. References were made as to...
The mistake we were talking about is a mistake as to what the agreement meant in relation to the prior position.
Well, I'm going to come to the mistake in a moment. I'm sorry, I've gone back.
You haven't got very long.
Yes. Well, in terms of the mistake, my Lord, this was on the point of joint controlling interest, where it was being said that this should have been shaped differently. Now, in terms of the mistake, the question was asked again as to whether it was a mistake of drafting or a mistake of fact. And my Lord, I want to make it clear what we are saying is it is a mistake of drafting, because yes, there was a factual assumption that this clause is going to apply to all the shareholders. But what goes wrong is that when the parties assume that the clause they are using, and in particular the reference, the incorporation by reference of the listing rules definition, is going to give effect to that intention. So the drafting goes wrong. Just think of this, my Lords. If there had been no reference to the listing rules definition, would there have been a problem? If there hadn't been that reference, you would then have to make sense of the controlling interest in the context of a clause which would not be referring to an outside
The problem is the
definition.
loss. You need to focus on the problem, which is the loss of controlling interest.
Yes, my Lord.
So that, I mean, looking at page 464, it seems to have been common ground before the judge that there had to be a loss of the controlling interest. And so that's the only issue.
Below, my Lord, the point was both ways, and I've given you the references earlier. The point was put that the clause, if read, if there was no controlling interest, then had to be read as change.
Yes, I understand that's how you put it now, but
No,
the judge understood it to be common ground that there had to be a loss. This is page 464 at the bottom.
That was,
That is
one of the
mistake.
alternative arguments, my Lord. I don't have time to go through the entire record now with you.
We've got your references and we can check them. But
My Lord, yes. But the point I was making is that the mistake is one of drafting. Because if you did not have the definition of controlling interest from the listing rules, then you would be focusing on the question, the parties have referred to the controlling interest, where do we find it? And you wouldn't be straitjacketed by the listing rules. So when my learned friend says, well, 11.2 was introduced for the avoidance of doubt, with respect, 11.2 in fact has, to a large extent, created the difficulty of understanding how this clause works. And at the end of the day, our submission is simple. If you, however way you look at the parties' agreement, when you step back from all of this, clearly those parties intended that the clause was to apply to all shareholders. And my learned friend's case proves too much. It operates in a way where that clause will never operate for two of the shareholders. And my lord, with respect to the submission that you need when looking for the controlling shareholder to look for 51% of the shares and you don't look at the representation, at the actual situation within the company, who was there, who voted. My learned friend submits you don't do that. Now, that is inconsistent with the listing rules definition of control. The reason why the threshold is not 50% but 20% is that a shareholder normally with 20% within a company...
He did say that, did he?
He did, my lord. Yes. But I think that is very important, and that's why I draw the board's attention to it. 20% is the objective threshold. Anyone above that has control. After that, you're looking at a question of fact. You're looking for de facto control. You're looking for effective control. And to focus simply on the event of October 2006, where for the only time in the life of that company, the shareholders' interest was ratcheted up through the press and they then turned up, is with respect not reflective of the normal situation of the company. The normal situation of the company, both prior to the October 2006 shareholders' meeting and after the October 2006 shareholders' meeting, is that people like Horace, like Pad and Anglo and La Prudence before, with something like 20% of the shares, slightly below for Horace, slightly below for the others as well, were de facto controlling that company. And that is what you're looking for under the second limb. You're looking for effective control. It's a question of fact. You're not looking for de jure control where you need to have 51%. Yes, well, just before completing, I wouldn't want to leave this unanswered. My other friend is drawing my attention to the fact that, of course, we dispute, and you will have seen the references in our letter of Friday, that the first argument, our first argument, is new. You will have seen all the references in our letter. It was in the agreed list of issues. It was live in the grounds of appeal before the Court of Appeal. It was live in the grounds of appeal to the board. And my lords, finally, just perhaps to finish on the last point taken by my learned friend, this contra proferentem point, if you could simply look at similar at page 8.
We didn't.
No, we're not interested in that.
It was just, I thought you might be amused, if I may.
Amused?
You might,
Oh, that's
which is why I wanted to finish by that.
Page
Page 826.
irresistible, isn't it?
I hope you will. I was. But,
Is that right?
826.
826 at the top of the page. And if you start perhaps from, the page before, this is his commentary on Article 1162.
Yes.
And top of the next page, I'll just read that paragraph, that first sentence. C'est aussi le texte auquel la doctrine classique, tout en reconnaissant son utilité, accordait la plus piètre estime, la situant hiérarchiquement juste avant le procédé de la courte paille. Maybe I have to translate that. La courte paille is drawing straws.
Yeah.
Yeah.
Thank you, my lord. Unless I can assist the board further, these are.
Thank you very much. the board will take time to consider its judgment and will hand it down in the usual way. The board is grateful to council for their submissions on both sides.